And it's indeed a pleasure and honor to be here at the invitation of SMU and the ACLF to speak to you all today about what is a quite a crucial topic. I don't have slides. I'll just be speaking, without slides because we just have a short time span. So I thought it's easier to deal with it just topic wise. So this is a paper that I've co-authored with Professor Dan Pushniak. So all credit goes to him, but at the same time, he cannot disown anything that I say today. Yeah. So this paper deals with one aspect of corporate governance, which is about shareholder activism in the climate space. To what extent can shareholders make a difference in addressing climate issues? Because as the theme for the conference suggests, corporations or companies are both the problem as well as the solution to climate change. So to what extent can shareholder activism be treated as a tool towards addressing the issue of climate change? So if we look at the phenomenon of shareholder activism, it is fairly new in the climate space because there's always been traditional shareholder activism, including hedge fund activism that we've all been very familiar with. But there was an important event that occurred in 2021 that changed things in this particular space, which is that there was a challenge to the board composition of a company which we all know, which is ExxonMobil in the US. And then relatively less known hedge fund in the US called Engine Number One managed to get 3 directors on the board of ExxonMobil, even though they held only 0.02% shares in the company. And how were they able to do that? They were able to do that because they were able to rally the support of a large number of other investors holding at least about 20% shares in the company, including the big 3, as they say, which is BlackRock. We already heard about the BlackRock effect, BlackRock, State Street, and Vanguard. So this essentially shook the whole field of climate-related shareholder activism, where people started developing this idea that, hey, shareholders can actually do something in the context of climate change. So the first question that some of us may think about is, why would shareholders do that? And there's a lot of literature about the fact that people like BlackRock have been very keen on the sustainable investment part of things. They are also conscious that their own investors are keen to see where they are investing. Are they investing in climate-friendly products or other investments? So there's a big push from the investment side towards climate-related shareholder activism. But I must also say that this is not a cakewalk for shareholder activists, because as we've seen in 2022 and 2023, there's also like an anti-ESG, anti-activist, woke capitalism kind of politically charged debate, particularly in the US, which has also resulted in something very interesting that happened just 2 months ago, which is ExxonMobil actually sued 2 of the activist investors called Arjuna Capital, and I think follow this. The 2 of the activists saying that they're doing too much in the name of climate. They're interfering in the internal affairs of ExxonMobil. So that's a big argument. Even the courts have sometimes accepted that argument that shareholders should not be asking boards to do too much because that's within the realm of boards. We're going to hear later today about that. So I'll leave that for the moment. But activism, whether we like it or not, is here to stay. Even if there's been a bit of a backlash in the US, there's a lot more going on in Europe. And I think a lot of what we saw in the earlier 2 presentations in Europe would suggest that there's more scope for activist intervention in Europe and other parts of the world than perhaps in the US, although some argue that the US setback is temporary and may not be long-term in nature. So I don't want to take a guess or a call on that, but I think it's enough for us to say that there's going to be some kind of activism in the climate space that's coming from shareholders. But the project that we undertook was to see, are there any roadblocks for shareholders when they seek to initiate climate-related actions, when they seek to bring about climate-related resolutions, which we see happening all over the world. And one of the things that we found in our research is that there are rules against shareholders coalescing, coming together, strengthening themselves by collaboration, because those rules prevent shareholders from coming together to exercise certain powers. And what are those powers? Those powers are essentially to prevent the change of control of the board, because that then falls within the scope of acting in concert rules, which as corporate and M&A practitioners and scholars, we are very familiar with what these acting in concert rules are, because those rules effectively prevent shareholders from coming together. So we then studied this particular phenomenon of shareholder activism in the light of these acting in concert rules, and then found that the acting in concert rules were actually created in a different era altogether. They were actually created in an era where there was a fear of backdoor takeovers by acquirers, abusive corporate control changes, and so on. Nothing to do with activism of the kind that we see today. So the argument we make in our paper, let's set it on in a gist and then maybe take us through some of the points, is that those rules actually need a rethink. And we make a case that activism should not fall within those acting in concert rules, although on the face of it, they seem to encompass activism as well. But that is not something that was intended. Those rules need to be reconsidered in the light of what we see currently. And I'll come to a little bit of a detail as to the proposal that we make. So in the light of this basic formula that we've set out in the paper, I'd like to run through with the limited time that we have on 3 basic points that we make in the paper, and I'll cover in the presentation. The first thing is, what is the case for shareholder activism in the climate space? The second is, how do actually the acting in concert rules prevent shareholder activism? And the third is, how do we put everything together and work out a model that we want to propose, which we do so in our paper. So when we look at shareholder activism in the climate space, there are 3 basic phenomena that we see. The first is, as I mentioned a little earlier, there is a lot of movement towards climate action by investors, no matter what their incentives are. And they're also propelled by measures such as the stewardship codes, the disclosure requirements that have already been mentioned early on. So there are many efforts that have been taken both privately and publicly that would motivate and incentivize shareholders to make climate-related actions. And there is evidence of that. I don't want to kind of get into the details of that given the limited time, but there's a lot of trends that indicate that shareholders have become active despite the kind of slight dip that we see in the US currently. So that's number one. The second thing is shareholders cannot act alone. Their strength lies in unity and collaboration. So the fact that they come together is an important component of shareholder activism, and that's where the acting in concert rules come into play. And here we see ad hoc collaborations among shareholders and also organizational collaboration among shareholders. And in terms of the organized collaboration, we see large international entities, and the name that comes up when we talk about this is the UN Principles for Responsible Investment, or the UNPRI, which is a major player in this space. So the UNPRI currently is represented by over 4,000 investors who have about $120 trillion in assets. So the UNPRI's composition membership constitutes more than half of the world's institutional investors. And the UNPRI is making a big push towards shareholders taking action towards climate-related issues in companies in which they have invested. And because of UNPRI and other associated entities or organizations that UNPRI has been involved in, it's very clear that collaboration is the name of the game. Right? So collaboration is something that is given, and that's something that UNPRI has pushed. And the third angle is, what do they collaborate for? Is it soft collaboration or is it aggressive collaboration? And soft collaboration has always been there. You don't need to be a shareholder of a company. You can always write a letter. You can be an NGO. Shareholders can also engage in soft collaboration or a soft engagement, which companies do not have any obligation to take note of. But where we see or likely possible success by shareholders is the kind of scenario we saw in engine number 1, where there needs to be a pain point for boards to take note. And the pain point is only when their board position is at threat. And we see possible scenarios where climate activists would bring resolutions and part of the strategy of the shareholders would be, if you don't go net zero by a certain period of time, as they have done in the case of many companies, we are going to bring about resolutions to overthrow the board or overthrow a majority of the board. So many of these climate resolutions are coming under the shadow of a potential board change. So what do we have here? We have here something which is activist shareholders coming together to threaten the board. And all of these constitute a lethal cocktail which directly entrap somebody into the acting in concert regime, which is currently there across the world. And what does the acting in concert regime do? It does three things. One is if shareholders are considered to be acting in concert, they have to make disclosures. And you might think that what's the point in making disclosures isn't just a routine matter, but that actually goes against the strategy of many of these shareholders who want to remain under the radar. And we see a lot of discussion and debate, including in the US, which reformed the 13D disclosures last year, where acting in concert was a very important component of the whole discussion about reforming this. Second, I think we're all familiar with that in Singapore as well, is the impact of acting in concert on the mandatory bid rule. And the mandatory bid rule is designed for control shift, but willy-nilly, it also takes into account scenarios such as shareholder activism. And there's a lot of debate and discussion that we go into in our paper, but we think the situation is not still satisfactory, because a lot of activism could also get caught within potentially takeover scenarios where activists could be required to make an offer, and that's the worst place that activists may want to be, because they never wanted control in the first place, and it increases the cost of acquisition. And the third is a fascinating phenomenon which is also occurring mainly in the US and also in Japan. Professor Shishiro has written about this, which is anti-activist poison pill. So in the US, we see a growth of anti-activist poison pills, where companies are setting up poison pills to prevent interference by shareholders. We've seen that in Japan as well. And a lot of that, although not initially towards climate or ESG, increasingly in companies, especially in the oil space, are worried about the impact of activism, and they're putting up these anti-activist poison pills. So there's some jurisprudence coming out from the US. If any of you are interested, it's on our paper. It's in the paper. There's a case called Williams Stockholder litigation, which is a Delaware case. There's a Mitsubishi case in Japan. So those cases have very interesting discussion about what is the scope of anti-activist poison pills. So where we end up is that these matters make it quite difficult for investors and their lawyers and advisors to undertake activist stances unless these issues surrounding acting in concert issues are taken into account. So finally, what is our proposal? The proposal that we make is actually very simply two. The first thing is we seek that rules across the world need to make a distinction between activist proposals and change of control actions. And activist proposals are different from the activists are not interested in controlling the company. They are interested in moving the needle on a particular issue on the company, which in our case is climate. So they should not be treated in the same way as those who want control over the company. So we need to rethink and view issues with a different lens altogether. And the second thing that we also propose is the relaxation of the rules on acting in concert probably need not be available to anybody and everybody, because that could then open up to the idiosyncrasies of individual investors who may start suing companies or bringing up actions. So what we recommend is maybe there has to be an organized way of climate activism, and we suggest that there needs to be intermediary-led intervention, and perhaps bodies like the UNPRI, which already have a vast membership, could be these intermediaries who could bring these actions, which could so-called create a safe harbor from these kind of activist rules. So that's really the point we are making in this particular paper. And the final issue, and I'll stop with that given the limited time, is the discussion that we've had, and I think it probably will come up eventually either today or in some of our discussions, which is climate equal to ESG? Right? And I think what we decided to focus on, and I think this is a debate that's come up in the last 1 year because of the backlash that ESG has received, is to focus largely on climate for three reasons. First is climate is an existential crisis compared to many of the other issues on ESG. Climate, as we have seen today in the earlier two presentations, is heavily legislatively driven across the world. And the third, as Rosa also mentioned, climate also is a material financial risk. So rather than open up the entire gamut of ESG, perhaps it might be good to start with climate and then see where things go before we look to expanding the scope. So that's really what we have, and we'd be again happy to take questions if there are any. Thank you.